esteemed judges and participants. We are thrilled to introduce our panel of judges whose expertise and fairness will guide us today. Today we have Advocate Divya Unnikrishnan. Ma'am is the additional government pleader and the public prosecutor in Chenganur. Welcome to you, ma'am. Next we have Advocate Bino George. Sir is practicing as a lawyer in Pathanamthitta District Court since the past 29 years. And he is an author of the book Film and Law. Welcome to you, sir. And we have Advocate Muhammad Ibrahim, sir. He has 4.5 years of experience as an advocate, 29 years as judicial service, and 5-year experience as a judicial consumer judge. Welcome to you, sir. This is the final round of the second National Mount Zion Moot Court Competition 2025. Total time allowed for each team is 30 minutes, 35 minutes, 30 minutes for arguments and 5 minutes for rebuttal. If you want any time extension, the judges will allowed it. Thank you.
Much obliged. The council seeks permission to address the bench collectively as your lordships and individually as your lordship and your ladyship. Much obliged, your lordship. Greetings to the honourable bench. I am counsel 1 on behalf of the petitioners in the case of Indian Association of Professional Artists versus Tech Innovate Private Limited and others. Your lordships, before the council will begin with the submissions, the council would like to submit a copy of the compendium to the bench. Much obliged, your lordships. Lordships, the council seeks permission to briefly state the facts of the case.
Yes.
Much obliged. Your lordships, Tech Innovate Private Limited is a technological company, and they have developed a generative AI, creative vision, whose data set is trained by multiple array of works, copyrighted works under Creative Commons licenses, and the work which are available under public domain. Using this data set, they generate images which are based on the prompts given by the user. Furthermore, your lordship, the petitioners in this case have claimed an infringement of the reproduction rights, exclusive reproduction rights, and immoral rights. Furthermore, they have also claimed that the referencing to their names and their styling also leads to public confusion and false endorsement, thereby leading to infringement of Trademarks Act 1999. Therefore, furthermore, the petitioners have also claimed unjust enrichment on behalf of the defendants. If your lordships are satisfied with the stated facts, the council seeks permission to proceed with the submissions.
Yes, proceed.
Much obliged, your lordships. Your lordships, the first submission that the council would be dealing with is whether the use of copyrighted works, including those under common licenses or in public domain, for training of AI constitutes infringement of Copyright Act 1957. Your lordships, the council would be making the submissions under 3 subheadings. The first being that there is being the application of substantive similarity test. Second being that there has been an infringement of the exclusive right of reproduction under section 14 of the Act. And third being that there has been an unjust enrichment. Your lordships, if the council would like to draw the attention of the court to flag number 5 of the compendium submitted. In R.G. Anand versus MS Deluxe Films and others, it was stated that a claim of copyright infringement would sustain if the copied material had resemblance with the original work. Your lordships, in para 6 of the clarifications issued, it was clearly stated that the work which is generated by the AI has a resemblance of about 65 to 80% with the work of the proprietors in the instant case. Furthermore, the clarifications also provided that the similarities are related to certain unique original styles of the artist and their thematic compositions which are unique to their created work. Furthermore, your lordships, if the council may draw the attention of the court to flag number 6 of the compendium. We have tried to explain how AI data sets are trained. Your lordships, while training of AI data sets, they are fed with certain complete literal copies of the work. Furthermore, if the council may draw the attention to flag number 5 of the compendium, in R.G. Anand case itself, the court had also relied on another case, Romesh Chaudhary versus Al Ahmad Noshwari, wherein it was stated that the colorable imitation of original work with purpose of deriving profit from it would amount to infringement. Your Lordship, it must be noted that the work which is generated by the AI is also being sold on an online platform called artistryonline.com. Furthermore, Your Lordship, if it may please the court, the council would like to deal with the second sub-issue.
Yes.
Much obliged, Your Lordship. Your Lordship, the second sub-issue that the council would be dealing with is whether there has been a violation of reproduction rights or not. Your Lordship, Section 14, Clause C, Subclause 1 of the Act states that the creator of the work, the creator of the artistic work has an exclusive right to reproduce the work. Your Lordship, reproduction in the section also includes storage of the work. While training the data set, the infringement not merely occurs with the final output. On the other hand, the infringement begins right at the point where the training of the data set begins. That is the moment they start storing data to train the data set for generative AIs. That is where the infringement begins, because the section also includes storage as reproduction. And for training of AIs, they are storing certain copyrighted works, thereby leading to an infringement of the exclusive right of reproduction enumerated under Section 14 of the Act. Furthermore, Your Lordship, if the Council may draw the attention of the Honourable Court to flag number 8 of the compendium, we have referred to the case Designers Guild Limited versus Russell Williams Textiles Limited. Your Lordship, in the case, it was stated that when it comes to artistic works, if the substantial features of the proprietor's work are resembling in the infringing copy, that would amount to infringement. It doesn't matter if in the infringing copy the same work amounts to be a substantial feature or not. The mere presence of the substantial feature would amount to infringement. Furthermore, in the same case, it was also stated that if we are able to demonstrate that there is sufficient amount of similarity and that the alleged infringer had also had prior access to the work of the proprietors, the burden of proof would then shift on the defendant to prove that they have not infringed. Furthermore, Your Lordships, if it may please the bench, the council would like to deal with the third sub-issue.
Yes.
Much obliged, Your Lordship. Your Lordship, the third sub-issue deals with unjust enrichment. Your Lordship, unjust enrichment is basically retention of benefit to the loss of another. While the Council is aware that unjust enrichment is not a remedy, is not something which is codified under the Copyright Act, but there is a remedy under Section 55 of the Act, which is accounts for profit, which is to say, if the proprietor's work has been used without his authorization to make certain benefits without taking permission from him or causing loss to him, in that case, he can always claim for something called accounts of profits, which means he can always claim the profits which have been gained by others by using his work without his authorization. If Your Lordships are satisfied with the submission, the Council seeks permission to deal with the second issue.
Would you clarify with the unjust enrichment and accounts matter?
Indeed, Your Lordship, indeed. Your Lordship, unjust enrichment, basically, as the Council stated, is an unjust retention of benefit at the loss of another. Your Lordship, in the instant case, the generative AI has been trained with certain copyrighted works which have been used to generate work by the AI. The work which is generated by the AI has high resemblance, as the clarification provides up to 65 to 80% resemblance with the works of the proprietor, which means that they're using the works of the proprietor and selling them in the market, Artistry Online, which is a market where they sell the generated images, which means they're also commercializing and they're also gaining benefits at loss of the artist, because the works of the artist are being used without their consent, and as the facts provide, they're not compensated for it either, therefore amounting to unjust enrichment. Now, Your Lordship, the Council is aware that unjust enrichment is not something which finds particular mention or explicit mention under the Copyright Act itself. However, there is something called accounts of profit as a remedy under Section 55, which means that if the infringer has gained certain profits without the permission of the proprietor by using his work, the proprietor can always rightfully claim for the profits gained by the infringer.
Then what is your locus standi to come before this court?
Your Lordship, we are an association of artists whose work have been used to train the data set without their consent and without giving any compensation to them. Our copyrights have been infringed under the Act and our moral rights as well.
One more question.
Indeed.
There's ample provision in the Copyright Act for filing a civil suit. Then why did you come with a public interest litigation?
Your Lordship, Article 32 allows us to approach the Supreme Court in any matter of infringement of fundamental right. directly to the Supreme Court. The Supreme Court has an original jurisdiction in that matter. Your Lordships, while the moral rights of an author, they are very inherently related to the personality of the authors. And the right of privacy under Article 21, if the council may direct the attention of the court to flag number 1 of the compendium, in case Puttaswamy versus Union of India, it has been clearly stated that right to privacy is also part of fundamental right under Article 21. Lordships, when a certain copyrighted work have been used for training the data set without their permission, without their consent, which means a part of their personality, a part of something which is so intrinsically related to them, have been used without their permission. Also,
No, I do admit that. But
Indeed.
that's not the question. The question is, you have an option in the civil law. You can approach in the law of torts. You can approach a civil court for the same remedy for compensation as well. Then why did you use the provision of this writ jurisdiction?
much obliged, Your Lordships. Indeed, there are provisions under the said Act, but Your Lordships, it is to be noted that this is also a matter of national importance, which is to say that this is something which has not been adjudicated in the Indian courts before. This is something also important in the contemporary world where technological advancement has taken the front foot and has been given so much importance. And therefore, it becomes very important to have jurisprudence of the Honorable Court on this matter. Much obliged, Your Lordships. If it may please the bench, the council would like to now continue with the second submission.
Yes.
Your Lordship, the second submission deals with if the exception of fair dealing under section 52 of the said act could be applied in the instant case or not. Your Lordships, if the council may draw the attention of the court to flag number 14 of the compendium, in Wink Limited and others versus Tips Industries and others, the court clearly stated that the exception, particularly under section 52 clause 1 subclause B, which deals with transient and incidental storage of work, would not be applicable if the storage is the central purpose of the work. Your Lordships, in the instant case, while training the data set, the storage of the copyrighted works or the works under common creative licenses are not incidental or transient. They have been storing the work with the very purpose of generating works which resemble the work of the artist. It is neither transient, it's neither incidental, it's the primary purpose, and therefore the said exemption could not be applicable in the instant case. Furthermore, Your Lordship, if the council may direct the attention of the court to flag number 7 of the compendium, in the Standing Parliamentary Committee report, it was also stated that there are certain exceptions where the exception of fair dealing could be applicable. The said exceptions being, the said exemptions have been only extended to education and research purposes as works which are available in digital form. Your Lordships, the AI here, the work generated by the AI is neither used for research nor for education purposes. It has been used for purely commercial purposes. They have been selling the generated work on a platform and gaining clear benefits from it. And therefore, the said exemption cannot be made applicable in the instant case. Furthermore, Your Lordships, the council would also like to submit that there has been a violation of the moral rights of the proprietor under section 57 of the Act. Your Lordships, if the council may direct the attention of the court to flag number 11 of the compendium, in Manu Bhandari and Kala Vikas Pictures Private Limited and others, it was stated that moral rights of the author are very paramount, and these rights are independent of the economic rights that the authors have. Your Lordships, even the works that are under common creative licenses as provided by the clarifications, there are certain types of common creative licenses, and even these works, they clearly require attribution. They have prohibited any sort of modification. Furthermore, Your Lordship, even when economic rights of a proprietor are curtailed or given up, the moral rights continue to sustain, because moral rights, they are independent of economic rights, and same have been stated in the cited case. Furthermore, Your Lordships, if the council may draw the attention of the court to flag number 11 of the compendium, in Amarnath Sehgal versus Union of India, the Delhi High Court has recognized that there are certain types of moral rights, which includes rights of paternity and right to integrity. Paternity, Your Lordship, deals with attribution. In the instant case, while the AI, the data sets have been trained with the copyrighted work, the final output has given no attribution to the proprietors of the work. Neither have the company, while developing the AI, given any sort of attribution, or taken any consent or compensation to the proprietors. Furthermore, Your Lordships, they have also distorted the work, which is obviously clearly prohibited when a work is under when a work is copyrighted. Furthermore, even the work under common creative licenses, the types of common creative licenses as provided by the clarifications, they prohibit any sort of modification. And the work generated by the AI, it bears clear resemblance, although it's not exactly the same, which means that they have distorted the work of the proprietor, thereby leading to an infringement of the moral rights. Furthermore, Your Lordships, a novel question that we have brought before the Honorable Court today is whether AI could be granted authorship or not. Your Lordship, it's very clearly stated that the current copyright law of India is not well equipped to deal with matters pertaining to AI authorship. To establish the same, the Council would like to draw the attention of the Court to flag number 14 of the compendium, where we have referred to the case of Navigators Logistics Limited versus Kashif Qureshi and others, wherein the court denied to give authorship to a company, stating that for a copyright to subsist, it's very necessary to have human authorship. Furthermore, Your Lordships, if there's another case that the Council have referred to, Telstra Corporation Limited and versus Phone Directory Property and others, wherein it was stated that on page number 19 of the memorandum submitted by the petitioners, wherein it was stated that a directory which has majorly been compiled by the work of computer software cannot be given authorship because it involves no application of human mind or human skill. Thereby, the importance of having application of human mind and human skill has been time and time again be highlighted by the court in multiple instances. And therefore, Your Lordships, AI cannot be granted authorship under the Copyright Act. If Your Lordships are satisfied with the submissions, the Council seeks permission to deal with the third issue.
Yes, sir.
Your Lordships, the third issue that the Council will be dealing with is whether the lack of attribution or removal of copyright management information during the training process violates Section 65A, excuse me, 65A and 65B of the Copyright Act. Your Lordships, TPMs, which are technological protection measures under Section 65A, are certain measures which are put into place to protect the copyrighted work. Your Lordships, these can be in form of certain inscriptions or codes or passwords. However, how an AI is trained, the process of training an AI is not something which is communicated to the public, which is to say that how an AI is trained is not a transparent process, which makes it very difficult to figure out the nature of infringement. However, they have used certain copyrighted works to train their AI, which means that they have managed to circumvent these protections, thereby leading to a violation of Section 65A. If the Council may draw the attention of the court to flag number 17 of the compendium, in Sony Computer Entertainment Europe Limited versus Harmeet Singh and others, it was stated that Section 65A would be said to be violated on two conditions. The first one being that there was a modification without the plaintiff consent, which the petitioners have already established that there was no consent taken. Second being that the respondent has infringed the petitioner's copyright by commercially making the modified version available, which they are also doing by selling the said work at artistryonline.com. Furthermore, Your Lordships, there has also been a violation of 65B, which is right management information. Lordships, in the 1996 WIPO Internet Treaties, the rights management RMI have been defined as follows: information which identifies the work of the author, which identifies the work, the author of the work, the owner of any right in the work, or information about the terms and conditions of use of the work, and any number of codes that represent such information. When any of these items information is attached to a copy of work appears in connection with the communication of work to the public. Which means RMI is certain information related to the work or the author of the work. And if such an information is removed while communicating the work in its material form or in any form with the public, there is a violation of Section 65B. Your Lordships, the work which is generated by the AI, as already established, has a very high resemblance with the work. However, they have removed the information which would attribute the copyright, or which would attribute the creativity to the creators of the work, thereby infringing Section 65B as well. If Your Lordships is satisfied with the submission, the Council would now like to invite the co-counsel to deal with the fourth and the fifth submission. Much obliged, Your Lordships.
Council takes permission to oppose the guys.
Greetings, Your Lordship. This is the co-counsel for the petitioners, and I will be dealing with the issue 4 and issue 5. Your Lordship, the issue 4 deals with whether the use of artist name and styles in the generated outputs violates the Trademarks Act 1999. Your Lordship, the case is as such that there exists trade dresses in the market on particular products which is associated with the petitioner's artworks, that is the IAPA's artworks. Your Lordship, and at the same time, the respondents are also putting out promotional materials for the promotion of their AI tool with the name and style of the petitioners. Your Lordship, the counsel for the petitioner is putting forward that there is first that the use of name and style can lead to public confusion, and second, the use of name and style can lead to false endorsement and thereon leading to dilution of trade dress. Your Lordship, the very importance of trade dress or a trademark is not only to give a clarity on the fact that a particular product does not belong to a competitor in the market. It also gives a clarity to the consumer on their consumer protection, Your Lordship, that it gives them the source and the quality of the good itself when they look at a trademark or trade dress, Your Lordship. Your Lordship, due to the similar work that is present by the AI tool, which is 65 to 80% resemblance to the petitioner's work, there is an inevitable possibility that the public will get confused regarding and the public will get confused that the petitioner's original work is associated with the artist, Your Lordship. So, Your Lordship, the trade dresses that are present, that can be taken as the the petitioner's original work by the consumers, and they are likely to get confused, Your Lordship. This leads on to the false endorsement, that is likelihood of association. The consumers can also believe that the petitioners are working with the respondents, which is not the case in this case, Your Lordship, because no consent has been taken for the trade dress and use of those artworks by the respondents, Your Lordship. Your Lordship, if I may refer the bench to the flag number 18 of the compendium, it refers you to the case of Cadla Healthcare versus Cadla Pharmaceuticals Limited. In this, Your Lordship, because there is no provision which directly determines what is public confusion, in this case it was said that when we are looking at public confusion, it is said you have to consider the goods that are being put forward in the market, the customers that are likely to buy that product, and what consequences it can bring when that product is put forward, Your Lordship.
Are you familiar with the term passing of?
Yes, Your Lordship.
That's it.
Indeed, Your Lordship, because the trademark is not registered in the case of petitioners as of now, Your Lordship. So there can be a request for the passing off of the due to an infringement that is already present in both, which is being used by the respondent. So there can be a request of passing off herein.
Trademarks need not be registered. Can be by practice also.
Indeed, Your Lordship. The trademark is not registered for both respondents and the petitioners as of now, Your Lordship, but it can be, the rights can be protected by the way of passing off, Your Lordship. Further, Your Lordships, in the Symphony case, Symphony Limited versus Group SEB Private Limited, in this itself, in this too, Your Lordship, on the flag number 19 of the compendium, it says that the visual impression of the product itself gives source to the consumers, Your Lordship. Your Lordships, if I may take an example, I request the Lordships to take yourself as a consumer, and you are aware of the IAPA's artistic works, you are aware of your Lordships are aware of the petitioner's artistic works, and you are aware of their name and style, Your Lordships. And at the same moment, you see the promotional material that is put forward by the respondents, Your Lordship. There is inevitably, and without knowing, a gullible customer, Your Lordship, will be drawn into the promotional materials, and the respondents will get a reputation and goodwill that was created by the petitioners, and they will directly get a goodwill and reputation that they did not create for themselves, Your Lordship. Further, Your Lordship, in the case of Abyss Exports India Private Limited versus Gunjan Nalode, in this case, on the flag number 22 of the compendium, in this case, to Your Lordship, the importance of trade dress was put forward. It was said that the petitioners in this case created a new artwork on a trade dress just for the purpose so that they can use them openly, continuously, and exclusively without any similarity or without any confusion for the public, Your Lordship. But in the case of the petitioners and respondents, the use of name and style which have been put forward, it contradicts or it brings down the whole purpose of the trade dress, Your Lordship. If Your Lordships are satisfied, the Council seeks permission to move on with the fifth issue.
Yes.
Much obliged, Your Lordship. Your Lordship, the fifth issue deals with whether AI tool Creative Vision itself qualifies for trademark registration under Trademarks Act 1999. Your Lordship, the Council is arguing the same on 4 grounds. First, that the Creative Vision, the trademark, it lacks distinctiveness. Second, that it designates quality. And third, a trademark is not limited to just the trade name, but it goes beyond the trade name, Your Lordships. And fourth, that the rights, if they are given to the respondents, it will be unjust, gravely unjust for the petitioners, Your Lordship. Moving on with the first sub-issue, Your Lordship. Under the Section 9 of Trademarks Act, Section 9 Trademarks Act 1999, it fully rejects a trademark which is not distinct in nature. Your Lordship, when we look at the name Creative Vision, we notice that creative and vision are just 2 common words separately. And when we compose them also, they just create another dictionary word, Your Lordships.
Yes.
If I may refer to the case of National Belco case on flag number 22 itself, Your Lordship, of the compendium, it was stated that in this case, Your Lordship, both the parties, the petitioners and the respondents, were using the trademark 50, that is 50, and the spelling of 50 as their distinctive, they were hoping for a distinctive trademark qualification for that word 50. But however, the Supreme Court in this case, the Indian Supreme Court, put forward that both of them cannot get a trademark on such a generic and common word because it lacks distinctiveness, Your Lordship. Further, Your Lordship, in the case of American Online's Inc. application versus AT&T Corp., this is a US case, Your Lordship, and it is on the discretion of Your Lordships to take this as a persuasive argument. In this case too, it was said that in this case, the petitioners were using, you've got mail as a distinctive trademark, Your Lordship. But this too wasn't allowed because these are just common words that are put together and it should be available for the public for use, Your Lordship. Further, Your Lordship, the trademark chosen designates quality. The Creative Vision trademark that is being spoken about here, the word creative, it can be seen as a laudatory word, Your Lordship. When the respondents put forward the product as under the name of Creative Vision, they themselves are calling their product creative, Your Lordship, and they're pulling the consumers towards them through this laudatory word. Your Lordship, if I may refer to the flag number 26 of the compendium, Burger King versus Ranjan Gupta case. In this case, Your Lordship, both generic and laudatory words were taken into consideration because burger being a common word and king being a laudatory word. It was said that 2 generic or laudatory words cannot create a distinctive trademark and hence cannot be registered, Your Lordships. Further, Your Lordships, as put forward earlier, the trademark, the trade dress being put forward and the promotional materials leads to public confusion, false endorsement, and hence dilution of trade dress, Your Lordship. Dilution of trade dress because the reputation and the goodwill of the petitioners can be brought down due to the AI generated image that is being put forward under the name and style of the petitioners, Your Lordship. Your Lordship, so the trademark goes beyond a trade name, Your Lordship. If the qualification of trademark is given, we are not just looking at the trademark itself, Your Lordship. We are looking at the nature and the goods of the product and what effects can it have on the consumers itself, Your Lordship. Further, Your Lordship, if these rights are given to the respondents for trademark registration, it will be gravely unjust for the petitioners. Because, Your Lordship, under Section 28 of the Trademarks Act 1999, it is said that if a trademark gets a registration under the Act, they have the whole authority to bring down any other proprietor that has been using this similar or deceptively similar goods or the artwork or the work that has been being used as trademark or trade dress. Your Lordship, being the similarity that we have seen under the clarifications, that is 65 to 80%, it is very clear that the AI has not merely taken inspiration but has copied the work, Your Lordship. When this registration is being given, Your Lordships, it is creating a unfairness to the petitioners, and it can bring down the petitioners further in the future, Your Lordship. The respondents can always come forward after getting the qualification saying that the petitioners are using our work instead, and the petitioner will be exposed to unnecessary legal challenges, Your Lordship.
How could you say that there is some deceit means for the respondents to use your name?
The council, indeed, Your Lordship, the council is not, we just want, the council just wants the court to emphasize, and we're just emphasizing that the court may see the consequence that can occur, Your Lordship. We are not, the council is not putting the blame on the respondents that they might come forward with these arguments later on. However, because a trade name goes beyond just a trademark goes beyond just the trade name, and this is why, Your Lordship, the council is emphasizing that the court may look into the future consequences that might occur, Your Lordship.
You are saying that the future remarks would make decisions.
Sorry, Your Lordship.
That you are saying that the future works or future will decide the deceit of respondents.
Indeed not, Your Lordship. The council is just putting forward that there has been an infringement of Trademarks Act, and further on, if the decision should be taken with utmost fairness, which the Lordships will be taking into account. But Your Lordship, we just wanted to emphasize that the Honorable Court may see the consequences that can occur, because there exists a section 28 under the Trademarks Act which allows the respondents to do so, Your Lordship. Your Lordship, if the court, if the bench is satisfied with the issues raised, may I move on with the prayer?
Yes.
In the lights of issues raised, arguments advanced, and authorities cited, the counsel for the petitioner humbly prays before the Honorable Court to adjudge, hold, and declare, first, that the petitioner should be awarded damages or accounts of profit for the unauthorized use of their copyrighted works, for violation of their moral rights, for the unjust enrichment obtained by the respondents. Second, that the use of petitioner's copyrighted works for training the AI system, creative vision, constitutes infringement in both Copyright Act and the Trademarks Act. And third, that the respondent should remove the AI-generated outputs that replicate the petitioner's artistic styles from their platforms. And fourth, Your Lordships, that the AI tool Creative Vision does not qualify for trademark registration. And to pass any order that the Honorable Court may deem fit in the favor of the petitioners to meet the ends of equity, justice, and good conscience. And for this act of kindness, the petitioners may be duty bound forever. Yes.
How could this court can grant damages or award damages? There is an original jurisdiction to award damages.
Your Lordship, as my co-counsel submitted, that the act itself allows for the accounts of profits when there is infringement of copyright.
You are moving under Article 32 or
Indeed, Your Lordship.
Different jurisdiction.
സിവിൽ ജൂറിസ്ഡിക്ഷൻ അല്ല
jurisdiction or writ jurisdiction?
Writ, Your Lordship.
Writ jurisdiction.
ആൻഡ് സീക്കിംഗ് സിവിൽ റെമഡി.
How could it go?
Your Lordship, there has been numerous cases where the Supreme Court has offered damages when it comes to national importance and violation of fundamental rights, and especially when the Act itself allows the accounts of profits to be put forward when there is damages infringing the copyright. Your Lordship, then the Council seeks request for the accounts of damages, Your Lordship. It was an honor arguing before you, Your Lordships.
Greetings to the bench. Before the council begins, if it may be of no inconvenience to your ladyship, can the council collectively address the bench as your lordships? Much obliged, your ladyship. If there are no clarifications with regards to the facts of the case, can the council proceed directly to the submissions? Much obliged, Your Lordships. I will be dealing with the first three issues which are in relevance to the Copyright Act, and my co-counsel will be dealing with the last two issues in relevance to the Trademark Act. With regards to the first three issues, before the council proceeds with the material fact submissions of the present issues, I would like to challenge the jurisdiction of the petitioners in the present case. They have approached under a public interest litigation under Article 32. I would like to place a twofold challenge upon the same. As far as the public interest litigation is concerned, through various cases, this Honorable Supreme Court has held that there should be three essentials satisfied. Firstly, the credentials of the petitioner should be checked. There must be a substantial public interest involved. And if there are different petitions and the one giving importance to the larger public interest must take weightage over the one with a smaller public interest. With regards to the first essential, credentials of the petitioners, they are a registered association under the Societies Registration Act. I would like to draw your attention to section 20 of this act, wherein a registered association is allowed only to act within the limits of its memorandum of association. So the burden of proof is upon the plaintiffs to show that this registered association of artists has the locus standi to represent the present artists in the present public interest litigation before this Honorable Supreme Court. It is to be noted this is different from a copyright society. It is a registered society under the Societies Registration Act. So it is not an inherent right for them to represent these artists in a copyright infringement suit before this Honorable Supreme Court.
How could you say that a society is not a part of state?
Apologies, Your Ladyship.
You are saying that for fundamental rights infringement, you can move for move under Article 30.
Certainly.
The prima criteria is that it should be a state.
Certainly not, Your Ladyship. As per the precedent held in Kaushal Kishore versus Union of India, it can be against a private entity also. Fundamental rights can indeed be enforced. We are not challenging them enforcing their fundamental rights against us. We are merely stating that there are no fundamental right violations at all. That I will submit that in my next argument, which is with relation to Article 32. As per Article 32, it is indeed a very exclusionary power of the Supreme Court, and the limits placed upon it are what the Supreme Court has given to itself through various judgments. At this juncture, I would like to refer to the case of Whirlpool Corporation as a registrar of trademarks, wherein if there is an alternative remedy which is present, it can be accepted. The petition under 32 can indeed be accepted in three conditions. It is humbly submitted that all three conditions, number one, violation of a fundamental right, number two, violations of natural justice, and number three, a bias of actors being challenged.
So if it is to enforce Article 19(2), reasonable restrictions under the Constitution, you can go for PAL, right?
Your Lordship, we are not the ones who are approaching this court for claiming any fundamental right violations.
No. If it violates your fundamental right, and if it is, a reasonable restriction has to be imposed, then what's your way out?
Your Lordship, we are a private entity. The reasonable restrictions are something which is under the power of the state. Our claim here is that there is no right under 19(1) itself violating.
You have to get it enforced by court of law only.
Certainly, Your Lordship.
And only through red jurisdiction.
Your Lordship, but the problem here is in the fact that they are filing a civil infringement of copyright suit, Your Lordship. The remedy for that is available in the Copyright Act, section 62 itself. If I may read out the same for Your Lordship. If there is any suit of infringement, either of a civil infringement or any other offense under this act, it shall be instituted in the district court having jurisdiction. The definitive article shall is being used here, which means the statute prescribes that it should be used. And through several judgments, the same has been upheld as well. Your Lordship, to answer your question, I would like to draw your attention to our compendium flag 1, which is Indian Performing Rights Society, which is Sanjay Dalia and another. This was a case where it was filed by another similar registered association trying to protect their art from infringement. And this was filed under section 20 of the Civil Procedural Code. The court observed the importance of section 62 of the Copyright Act and 137 of the Trademarks Act. Both deal with the same jurisdiction for approaching in the case of infringement. Both have to be filed in front of the district court. And they redirected the petition which was filed in the High Court under 20 CPC to go before the district court, Your Lordship. That being the case, if there exists a statutorily prescribed alternative remedy.
So you are saying that Supreme Court has no original jurisdiction?
Certainly not, Your Ladyship. The Supreme Court most definitely has jurisdiction. However, the restrictions placed upon it are to ensure that cases of utmost importance are given more priority. And we have further reasons, and with my forthcoming arguments as well, I'll substantiate how this present case is a completely unnecessary public interest litigation, the present matter. Your Lordships, if you are satisfied with the jurisdiction aspect of it, can the council proceed with the material aspects of the much obliged, Your Lordship. Firstly, Your Lordship, with regards to the issue 1, whether there is any case of infringement under the Copyrights Act, I would like to make my first submission on the grounds that AI generated art can also be copyright protected. For this, I would like to list down the essentials of copyrights, which is that it should be for an expression and not for an idea. Secondly, it should be some original work. And lastly, there should be some form of fixation. First essential, that it is an idea, it should not be an idea and should be an expression, is satisfied because whatever the AI generates is a final product, it's a final piece of artwork which satisfies to expression. The third essential, which is fixation, is also satisfied because digitally being fixed in a computer screen is also counts as enough fixation. The second essential, now coming to the second essential, which is originality. In Indian law, original works are only protected as per section 13 and 14. For deciding if a work is original or not, there are 3 different doctrines to be used worldwide. The lowest bar is one used in the United Kingdom, which is the sweat of the brow doctrine. This was held in the case of Walter versus Lane, a landmark judgment. Basically, what this doctrine says is that as long as me as a creator, I'm putting in some degree of effort into creating said work, that is enough to grant me a copyright protection. Your Lordships might be giving me some address. If I note down the same, whatever I've written down would be entitled to copyright protection. This is the lowest bar for originality decisions. The highest bar is something followed in the US. This is the modicum of creativity doctrine. As per this doctrine, apart from the effort being put in, there should be a significant degree of creativity involved to differentiate the original work from whatever work I have created. This was in the case of phased publication, it was a rural telecommunications inc. And in India, we follow neither of these. We follow something in between, which is called the skill and judgment test, as it was held in the case of EBC or DP Murdoch, where the court observed that in India, it is neither reasonable to follow the lowest sweat of the brow doctrine, nor the highest modicum of creativity doctrine. So it is essential what is being followed in India is something that is significant to India based on its legal circumstances, and that is why the skill and judgment test is being followed in the present country. My contention is that artificial intelligence generated art satisfies the upper limit, which is the modicum of creativity test itself, Your Lordships. To substantiate the same, I would like to give an example of the same, which is this generative AI. Firstly, Your Lordship, generative AI has 2-step processes. By the Learned Council, by the Learned Sister Council, there were multiple claims being made about how this artificial intelligence is infringing in the step of using it for training itself. There are 2 steps. First is the training process, second is the generation process. It should be clearly understood that the training and generation are 2 different processes, and they are not, one might have a consequence on the other, but it is not that they are the same action happening in one sitting. As far as the training process goes, there is a clear exception given with regards to fair dealing for the same under the Act if it is being used for a research purposes. Your Lordship, I would like to pose a simple question. If, as a human, I look at 20 different artworks and try to imitate their style and create my own painting, if the same can be copyright protected under the Indian law, why is it that if I am capable of making a computer system doing the same act which I did on my own, that cannot be protected under the same law, Your Lordship? That is our contention with regard to infringement in the present case. Additionally, Your Lordship, there were several contentions raised with regards to colorable imitation being done by the AI, and that it is affecting the artist's profit. Firstly, Your Lordship, I would like to move on to the next submission with regards to infringement per se. Infringement is a question of fact, not a question of rights or something else. If they are submitting the same in the present case, I would like to refer to 2 different tests which have been used by Indian courts in landmark cases to determine in artistic work whether it amounts to infringement or not. The Learned Council for Petitions has cited several different cases such as R.G. Anand's Deluxe Films, but that is a cinematographic work. The test used in a cinematographic work or a literary work may not necessarily be applicable to an artistic work. So based on the Indian precedent of C. Kannaya versus Balraj, the test used was substantial taking test. Essentially, Your Lordship, the same was also cited by the Learned Council for Petitioners using the case of Designers Guild versus Russell Williams. If I am making an artwork and a substantial portion of my artwork is based on some other existing artwork, that would amount to copyright infringement. Your Lordship, they relied based on forensic reports of 65 to 80%. However, in the same case cited by the petitioners, Designers Guild versus Russell Williams, I would like to mention what the court observed, that the substantial element must be there in the new artwork. 65 to 80% does not matter at all. Your Lordship, it might be 99% similar to the original artwork, but if that 1% is the substantial element, and if that has not been copied from the original artwork, they should be considered as different pieces of artistic artistic work, and both should receive copyright protection for the same, Your Lordship. So the mere fact that they are relying on a forensic report which does not even specify where they found the 65 to 80% from, for which artwork specifically the case of infringement is being claimed by the petitioner. None of this has been specified firstly, and they are additionally claiming that the AI, all AI generated art is indeed infringing upon their artworks. So, Your Lordship, as going back to my first point, if they are instituting a suit for infringement, it should have been in the honorable, before a district court. If their actual claim was a public interest litigation, once they had gotten a suit, a judgment from the district court claiming it is indeed infringement, then they could have approached this honorable Supreme Court with a valid proof of how it is infringement and then claim that their fundamental rights are being violated. That is not the process followed by the petitioners in the present case. At this juncture, going back to the public interest litigation, I would also like to recite another case, which is ANI versus OpenAI Technologies. This was a case which has recently been filed before the Delhi High Court. This was under 20 of the CPC. Similar, very similar question to the fact of the case at the hand, wherein the question of whether AI generated output can be copyrighted, can infringe upon copyright of other people or not. Your Lordship, this same case, however, it is different from the present case, as the petitioner seems to be relying on a forensic report, a baseless forensic report that does not even look into how the AI works, whereas the ANI versus OpenAI, there has been a clear step analysis of how the AI works and how it analyzes the data. None of that references have been provided by the petitioners in the present case, so to be making a claim that the AI artwork is infringing is absolutely wrong in the present case, Your Lordship. Your Lordship, if there are no further questions with regards to infringement, I'd like to move to my next submission regarding fair dealing. Firstly, Your Lordship, there is no infringement, as I had previously stated. Assuming there is infringement, the exception of fair dealing would apply. I would like to rely upon the exception of fair dealing through three different submissions. Firstly, the concept of review. If you may refer to a compendium flag number 5, in the syndicate press of University of Oxford and Cambridge, this is B.D. Bandari. The same case, essentially what had happened was the defendant had copy-pasted questions from the plaintiff's book. This was claimed as a copyright infringement by the plaintiffs. The court's analysis of the same was that because the concept of review, because the defendant has reviewed the questions before they had copied, for that reason alone, they have given a copyright protection. Even if we assume that the training part and the generation part are to be considered as one, the mere fact that the AI also reviews this art and analyzes every single element of it should be enough grounds to grant it the exception of fair dealing in the present case. The second is the principle of reverse engineering. Although it is not something that has been explicitly used in the Indian jurisprudence, it has been used in the US case and would have persuasive value. Basically, in the case of J.C. Bamford versus Action Constructions Limited, the petitioners had, the plaintiffs had created a certain set of artistic drawings and had made a model out of the same. For this is made a JCB out of the same. The defendants had looked at the model of the petitioners, reverse engineered the particles, added their own additions to the same, and applied for a copyright and acquired the copyright for the same. The question was whether this amounts to infringement or not. The US courts held that the fact that they had taken the effort to reverse engineer and apply their own creativity in the extra addition is enough grounds for granting of protection for the same aspect. So under the review and reverse engineering principle, it would be entitled to the defense of fair dealing in the present case. Additionally, once again, if you may refer to compendium flag 6 of us, this was the case of ESPN Star Sports versus Global Broadcasting Network, Global Broadcasting News Limited. The question of fair dealing can only be judged on the facts and circumstances of each case as noted by Justice Winkleman in the case of Media Works NG Limited, the Sky Television Network. Once again, very identical to infringement. Infringement itself is a question of fact. There has been no proper material fact submitted to substantiate the petitioner's claim. In the case of fair dealing also, there must be some claim of infringement which is in the question of fact, and additionally fair dealing is also a question of fact. So until the petitioner shows up with an exclusive artwork made by the AI and an artwork made by the artist, and this honorable court determines the substantial element of the artist's work is present in the AI, it cannot be considered as infringement at all, let alone fair dealing not applicable in the present case, Your Lordship. Your Lordship, if there are no further questions, the council would like to move to my next submission. Apologies, Your Lordship. Just before that, I would like to answer one simple clarification as well. With regards to fair use. Fair use is a more liberal principle used in the United States of America. And I would like to refer to the landmark case of Folsom versus Marsh, which observed 4 criteria for the same. Nature and objective of selection, the quantity and value of the material used, the degree of prejudice to the original work, and the diminishing nature in the original work. How much there is a diminishing in the original work. Your Lordship, firstly, with regards to nature and object of selection. The selection is done certainly with regards to what work is available in the public domain. However, it is being done only for AI training per se. It is not a copy paste that is merely happening. It is not merely a copy paste that is happening in the present case. That being said,
The intention has to be considered. The intention has to be considered.
certainly, Your Lordship, the intention is to train the AI model. If as a human I am allowed to look at these artworks and study from the same, I should also be allowed to create a computer program which can study from the same, Your Lordship. The AI is merely a tool. The Copyright Act provides for relevant provisions for protecting the interests of the true owners of the copyright, Your Lordship. That is my submission with regards to the same.
But using others' ideas and thoughts.
Your Ladyship, I would like to make an open claim that any creation is a product of everyone's ideas and thoughts. However, with regards to a specific thing, even if it is considered to be the artist's work, for the training process, it falls under the exception of 52 clause 1 clause A, Your Ladyship, because it is for the personal use of the AI system for its own research. What
Here,
it...
here the allegation is not that.
Apology, Lord.
It's not only used for artistic purposes or training purposes, but the allegation is that you are using it for commercial purposes.
Your Lordship, my contention is that
So it doesn't come under fair use.
Your Lordship, the commercial purpose would definitely be applicable to us because what we are generating is itself original work under the Copyright Act and the same is entitled to be protected under the Copyrights Act, Your Lordship. They have not shown any materials proof to show that it is a case of infringement in the present case. If it is not infringing, why are we not...
But the works are squarely protected under the Copyright Act.
The works of the artist are definitely protected, Your Lordship. The AI learning from the artist's work is identical to a human learning from the artist's work. If a human is allowed to look at an artist's work and learn from it, the AI should be allowed to look at the artist's work and learn from it. If a human can paint after learning from an artist's work, the AI which a human has created should be allowed to paint after looking at the artist's work, Your Lordship. That is my contention. And the work created is indeed an original work made by the AI in the present case, Your Lordship.
So you are saying that there is some thought of deception in your thoughts.
Certainly not, Your Lordship. Our goal is to advance technological development. If I may draw your attention to the 161st ministerial report on by the Ministry of Industry and Commerce, they had very well made it clear that AI and IPR laws should go hand in hand and there must be some interpretation given to grant protection to AI generated works as well. So that being the case, while the country itself is moving forward towards technological development, the mere fact that these artists are claiming this AI is infringing without any material proof has no value before this honorable court, Your Lordship. We have no intention to infringe upon their copies. We are merely creating a system to learn from the artist's artworks. And the system is capable of recreating different original artworks, Your Lady.
All these works are expressions of a person.
They are expressions made by the AI in assistance with the prompt given by the user, Your Lady.
And it will squarely come under the fundamental right.
Which fundamental right specifically, Your Lady?
Expressions.
Under 19(1)(a), Your Ladyship. Certainly, Your Ladyship, everyone has a fundamental right to speech and expression, Your Ladyship. However, Copyright Act provides an exclusionary, it's a negative right against preventing others from exercising said fundamental right of using one speech and expression as portraying it as another's. In the present case, that is not what is happening. We are creating our own artwork through the use of artificial intelligence. It is merely a tool. It is a tool made for assisting humans. As much as, I'll give an even more simpler example. If I carve a rubber stamp it on a piece of ink and do it on a...
They are stealing some ideas from others and using it for you.
Indeed not, Your Lordship. They are learning from the ideas of others and creating new artwork. There is a complete difference in both the submissions, Your Lordship. They have not shown proof of us stealing in any manner or form. And if it is not stolen, there is no case of infringement. We are not infringing upon their work. Ours is an original work which satisfies all essentials of Copyright Act. If ours is an original work, the same should be liable to be protected, Your Ladyship.
Proceed.
Much obliged, Your Lordship. With regards to issue 3. Issue 3 deals with, due to paucity of time, I'd like to quickly wind up this issue, 65A and 65B. The Learned Counsel for Petitions had clearly explained what constitutes rights management information and digital rights management. For 65A per se, there are two essentials as given in the statute itself. Firstly is the intention to circumvent, secondly is the circumvention process itself. As far as the intention to circumvent is concerned, we are not at all trying to steal from them, Your Ladyship. This artwork is something available in the public. They definitely have license for it, and licensing is a provision given under section 30 of the Copyright Act. Where should this licensing contract be followed is when we are ditto using their artwork. If we copy paste their artwork and we claim it to be ours, in that case we'll be violating the license. However, if we copy paste the artwork and something has a CC BY license, Creative Commons BY license, it means, and if we give the name of the artist itself, that would not be a violation of the license. However, in the present case, we are not at all copy pasting the artwork. We are nowhere portraying the artist's work as our work. We are nowhere misrepresenting the artist or violating their moral rights at all in any manner or form. We are merely using it to train a technological device to learn about how artistic works are done, your ladies. So that being said, intention is not proved in the first scenario. Secondly, circumvention, that there should be an active effort done by the defendants to circumvent the existing protection measures. My humble submission is that there is no such active measures because the AI learns from whatever is already present and creates its own art from scratch. So the ownership of copyright for the same should fall with the AI system, and that is a different question in the present case. However, the ownership is not what is the artist's work and it is not being copy pasted in the present case. Therefore, the circumvention essential is also not satisfied. Therefore, it's humbly submitted that 65A and B cannot be submitted in the present case, cannot be enforced in the present case, your lord. Additionally, your ladyship, I'd like to make one last submission. If an AI model has to include, assuming 65A, the rights management information is to be included. If an AI model has to include details of all the artist's work it has relied upon to come to this final product, that it means every single human who has made a painting must also disclose every artwork he has learned from to be an artist at the point and make a painting he's making at the present case scenario, ladies. So that being the case, it is completely illogical to request the AI to follow rights management information wherein the original piece of work is itself created by the artificial intelligence, the present case, ladies. If there are no further questions, the council would like to leave the podium for my co-counsel.
Yes.
Much obliged, your lordships.
It would be of no inconvenience to your ladyship. The council would like to represent the bench collectively as your lordship. Much obliged, your lordship. The council respectfully seeks permission to move to issue number 4 and 5. Much obliged, your lordship. The issue number 4 deals with whether the use of artist names and styles in AI-generated outputs violates the Trademarks Act 1999. Before diving deeper into the issue, the council would like to reinstate the fact in a single line, which states that artists have alleged, which includes that the artists have alleged that the creative vision is infringing their trademark, trademark of the artist under Trademark Act 1999. I would like to deal this issue with by dividing it into further sub-issues. The first limb of my argument would be that the artist name and style shall not be protected under the Act. Before arguing deeper into this issue, I would like to state the definition of what a mark is under the Trademarks Act. Section 2 clause 1 clause M of the Trademark Act defines what a mark is. A mark includes a device, brand, heading, label, name, sign, word, letter or any combination thereof. It shows that it is the intent of the legislative to exclude the definition of, to exclude the artistic styles under the definition of what a mark is. Also, it is clearly defined and mentioned in the US law in the Lanham Act of 1946 under section 43A that artistic style which includes the trade dress as well. But it has not been explicitly mentioned in the Trademarks Act of 1999, your lordship. Also, now moving to the section 28 clause 1 of the Trademarks Act, which provides that the subject to other provision of this act, the registration of a trademark shall, if valid, give to the registered proprietor of the trademark an exclusive right to the use of trademark and in relation to the goods or services in respect to which the trademark is registered and obtain relief in respect of infringement of the trademark in the manner provided by this act. This provision establishes that the trademark arises from registration, not merely in the existence of a name, your lordship. Also, in the case of Milmet Industries versus Algerian Incorporation, the Supreme Court has held that a trademark must be registered in India to claim exclusivity, which is not in the present case, your lordship. Also, I would like to draw the attention of the bench to the compendium flag number 7. The same case has been cited by the learned counsel for petitioners as well. In the case of Cadila Healthcare Kadila Healthcare versus Kadila Pharmaceutical Limited, it has been clearly stated that the action for infringement is a statutory remedy conferred on the registered proprietor of a registered trademark for vindication of the exclusive right to the use of the trademark in relation to those of goods, Your Lordship. Also, Section 2 Clause 1ZG of the Trademarks Act defines what a well-known trademark is. A well-known trademark is a trademark that is a mark that has become widely recognized by the public, that it enjoys protection across all the classes of goods or services without even registration, Your Lordship. The petitioners in the present case does not meet this criteria as they have not achieved a significant degree of public recognition. Notably, in the lieu of public interest litigation, the petitioners cannot claim well-known trademark status merely through authorship of artworks, as the status is reserved for the marks with substantial goodwill and reputation, Your Lordship. Now moving to the next limb of my argument, that an artistic style does not qualify for a trademark. It is a settled.
One moment.
Much obliged, Your Lordship.
I'm of the opinion that trademark registration is not mandatory. It's long usage that can also make you legal.
Much obliged, Your Lordship, but this Supreme Court in a plethora of cases has stated that it is mandatory for the uses, it is mandatory to register the trademark in order to claim infringement, Your Lordship. The same has been held in the case of Milmeth of the Industries versus Algreen, Your Lordship.
Yes.
Much obliged, Your Lordship. It is a settled principle that any mark can be entitled to be a trademark protection, just that it must be capable of acting as a source identifier, which requires inherent distinctiveness and acquired distinctiveness. Inherent distinctiveness means it is not generic or descriptive. Acquired distinctiveness meaning consumers recognize the mark associated with a particular source, Your Lordship. An artistic style by its very nature is broad and shared among multiple artists, preventing it from serving as an indicator of a single source. Also, in the case of Venugopal versus Ushodaya Enterprises Limited, the Supreme Court held that a mark to be protected, it must be capable of exclusive association with a particular trader, Your Lordship. Since multiple artists use similar styles, no artist can claim exclusivity, making the artistic style inherently non-distinctive, Your Lordship. Now, moving to the next limb of my argument, that is, there is no likelihood of consumer confusion or misrepresentation. The council would like to state the case of N. Rangarao and Sons versus Anil Garg and others. There are certain points to be taken into consideration to see if there is a potential deceptiveness, Your Lordship. The essential of the same are similarity. Your Lordship, as already argued by my co-counsel, this artistic works of the AI has passed the substantiality test and the lay observers test, Your Lordship, making it qualify for distinctiveness, Your Lordship. Also, the next essential is strength of trademark. Strength of trade as already argued by this council. Both the artist name and style doesn't inherent the status of well-known trademark protection, so it doesn't satisfy this criteria as well. Also, the next element is likely degree of purchaser care. As it will be argued by this council, there are two different markets, and both the artist's work and the work of the AI platform are from different classes of goods, which will be argued by this council in the upcoming issue. Also, the defendant's intent. The defendant even openly acknowledged the works of the artist by giving attribution to their works, Your Lordship. So, there is no any intent to establish the same, Your Lordship. If there is...
Saying that each and every individual's expressions or artist's work have no individuality.
Indeed, no, Your Lordship. It does have individuality, but it is subjective to the council seeks permission for 2 minutes to wrap this. Much obliged, Your Lordship. Also, in the present case, Creative Vision does not sell or market any. Sorry, Your Lordship. Indeed, no, Your Lordship. It is subjective to the work of the artist and the work of the AI platforms, Your Lordship. If to claim the individuality, to pass the test of the individuality, the counsel of the petitioner should have reached to the district court or to the registrar to satisfy the same, Your Lordship, and not under the public interest litigation, Your Lordship. Much obliged, Your Lordship. Also, the Creative Vision does not sell or market any product that directly competes with the petitioner's work, Your Lordship. The platform operates as an entirely different platform from the traditional artistic criterion or branding associated with the petitioners, Your Lordship. The petitioners' works belong to the artistic dedicated platforms and are part of market especially for the artist, Your Lordship, and Creative Vision operates in a technological and digital innovation platform, Your Lordship. These are fundamentally two different markets, further negating any potential trademark confusion, Your Lordship. Also in the case of Kraft Jacobs Limited versus ITC Limited, where this Supreme Court of India held that the trademark infringement or passing off cannot be established when the goods or services operate in entirely two different markets, as there is no likelihood of consumer confusion, Your Lordship. If there is no question, the council would like to move to the fifth issue, Your Lordship. Yes, much obliged, Your Lordship. Fifth issue deals with whether the AI tool Creative Vision itself qualify for the trademark registration under the Indian law. Due to time inconvenience, I would like to argue this simply. The first limb of my arguments is that under section 2 clause 1 is that B, as already stated by this council, it defines what a trademark is. It must be capable of graphical representation and distinguish the goods or services distinguish the goods or services of one from those of others. To analyze the distinctiveness and source identification of this trademark of Creative Vision, the phrase is neither generic nor merely descriptive of AI tools. Instead, it suggests an association with innovative content creation, making it inherently distinctive under the Abercrombie and Fitch Company versus Hunting World Incorporation test. This case established a 4-tier test, including generic, descriptive, suggestive, or arbitrary. Applying this test to the Creative Vision, it is not generic, as it does not define a category of goods or services. Unlike terms like AI art generator or design software would be generic terms, but not this. Also, the Creative Vision is not merely descriptive, as already argued by this council. Also, the Abercrombie test further establishes that suggestive marks requires a mental leap from the term to that of the products and services. Creative Vision fits this category, as it does not explicitly define the AI's purpose, but rather implies creativity and foresight. This makes Creative Vision inherently distinctive without requiring proof of secondary meaning, Your Lordship, satisfying the text of non-functionality doctrine, Your Lordship. The council will
Yes, you complete.
Much obliged, Your Lordship. Additionally, the Creative Vision services fall under the class of 42 of the 4th schedule of Trademark Rules 2002, which says that it is eligible for trademark protection under the Trademarks Act 1999. Class 42 specifically encompasses scientific and technological services, including software as a service, platform as a service, and AI-generated content services, Your Lordship, all of which aligns with the Creative Vision's trademark. Also, under section 35 of the Trademarks Act, which states that, 1 minute, Your Lordship. 35 of the Trademarks Act, which states that nothing in this act shall entitle the proprietor or a registered user of a registered trademark to interfere with the bona fide use by a person of his own name or that of his place of business, Your Lordship. And here we have used the name of our own company, Creative Vision AI Technologies, Your Lordship.
If the product is not original, if the product is not original, then how can you say that it's distinctive? For qualifying for a trademark?
It is original, Your Lordship. It is original artwork of the AI, which has been inspired from the artistic works of the artist, Your Lordship.
The trademark or the copyright will go to the A, not for the individual.
But AI indeed is not a juristic person, Your Lordship. So it will it will be given to the Creative Vision AI Technologies or Techno Innovation Limited, Your Lordship.
Then you cannot claim for the trademark or for the copyright.
Yes, Your Lordship, we can claim trademark or copyright under the name of the Techno Innovations or
It is not human creation, you cannot claim any trademark or copyright for that.
Indeed, yes, Your Lordship, it is the creation of the juristic person. The juristic person, the Techno Innovations Private Limited, have created the tool AI, created the AI tool, Creative Vision, Your Lordship.
The product, the final output is created by AI. It's not a human being.
Yes, Your Lordship, but the Creative Vision itself was created by the Techno Innovations Limited and the Vision AI Technologies, Your Lordship. If there is no question, the Council would like to state the plea. Wherefore, in the lights of issues raised, arguments advanced and authority cited, it is most humbly paid before this honorable court that it may be pleased to dismiss the petition and or pass any other order or orders that it deems fit in the lights of justice, equity and good conscience. For this act of kindness, the respondent shall be duty bound and forever pray.
The Council seeks permission to proceed with the rebuttals. Yes. Much obliged, Your Lordships. Your Lordships, the Council would first like to deal with the maintainability of the petition that was questioned by the respondents. If the Council may direct the attention of the court to flag number 2 of the compendium, we have cited a case, Indian Banks Associations versus Devkala Consultancy Services, wherein it was stated that in multiple instances where the petitioners may have moved to the court in furtherance of a personal grievance, if the court finds it necessary that the matter brought before the court is something which has national concern, is something which might affect public at large, they have very well entertained the case in that interest.
How an individual work will affect public at large?
Your Lordships, in the contemporary world where technology, where a large amount of investment, a large amount of focus has been on the technological advancement, AI has been something which has been under creation very often, which is to say that there are multiple AIs in work now which are used by a large number of people. Your Lordships, AI have now gained momentum in the current economy, and if the said AI, if the creation of said AI violates any fundamental right, that indeed becomes a matter of public concern, of national concern. Article 21, Your Lordships, as I have already argued while dealing with the first issue.
And how could you say that it would come under Article 21?
Your Lordships, as the Council had first referred to Amarnath Sehgal versus Union of India, where they have identified the moral rights of the author and the personhood theory, which is that every time somebody creates a work, it's an extension of their personality. Your Lordships, privacy, the right to privacy under Article 21, as recognized by the Honorable Court in K.S. Puttaswamy versus Union of India, it also includes autonomy on the said personality, autonomy on to what extent the personal information of a person can be used. Your Lordships, when TPM are, when the TPM is circumvented, when the personal information is removed while using the work, there is a clear violation of fundamental right. And therefore, the claim has been brought before the Honorable Court under Article 32 of the Constitution. Furthermore, Your Lordship, the respondents have also claimed that similarity, even if there is 99% similarity but 1% substantial similarity does not find resemblance, it won't amount to infringement. However, it has been clearly provided that resemblance of 65 to 80% is of the original style, of the unique artistic style, which is indeed the fundamental, which is indeed the essential feature of the work created by the proprietors. Therefore, there is resemblance to their substantive feature, thereby amounting to copyright infringement. Furthermore, Your Lordships, they have referred to the case of Eastern Book Companies versus D.B. Modak, wherein they have said that the three doctrines of originality, sweat of the brow, modicum of creativity, and then skill and labor. However, they have failed to address a very novel question in this case, which is that the skill and labor in the instant case that they are talking about is skill and labor of the AI. However, the said doctrines have clearly been applicable only on human authorship and human creativity or skill of labor of the human mind, not of AI. Furthermore, Your Lordships, the exception of fair dealing is only applicable when the said where the said use has been done for research purposes, which the Council has already negated by clearly showing that they have been selling the work on artistryonline.com, thereby commercializing the use. And the particular exception under section 52 clause 1 subclause B, which is transient and incidental storage, is also only applicable when the said storage is not the primary course of the work. However, the AI being trained, the storing of the work has been primarily done to train the AI, which is the storing is done for a primary purpose, not for any incidental purpose. Under section 14 of the Act, storing also constitutes infringement, which means that infringement is not necessarily limited only to the output generated by the AI. The infringement begins right at the stage where they start storing the copyrighted work without their consent. Furthermore, Your Lordships, work being publicly accessible does not mean that the work is also in public domain. Thereby it cannot be defended by saying that the work is publicly accessible and thereby a claim of copyright infringement cannot be
One more
maintained.
question. How can you give the compensation? This court cannot order and realize compensation. So what's the mechanism you planned or you suggest?
Your Lordships, there have been instances, as the council has already stated, where a party has moved to the court in furtherance of a personal grievance. The court can very well direct damages to be given while also addressing questions of national importance or infringement of fundamental rights. And thereby the claim has been brought before the Honorable Court.
How it could be realized? That is the question.
Pardon, Your
How
Lordship?
it can be realized?
Can you suggest any mechanism?
Mechanism. Whether this
If-
original jurisdiction has any power to execute such an order.
Your Ladyship, as the council has already stated, that obviously the Honorable Court has a jurisdiction to decide any matters regarding
No, that is not the question. How it could be executed? That is the question. That has to be considered.
Your Lordships, if it deems fit to the Honorable Bench, they may direct for compensation of the artists who have been, who have incurred loss.
Concede. But the question is specific that how it could be executed. If we allowed your relief,
Your Lordship,
how it could be executed.
indeed, Your Lordship, by directing the company Tech Innovative to compensate for the damages. Your Lordship, Article 21, as stated in KS Puttaswamy versus Union of India, has not limited to vertical effect. It also has horizontal effect, which means a claim under the same can be brought against private entities as well in the Honorable Court. If Your Lordships are pleased, the Council would like to.
Something.
Furthermore, Your Lordship, as the Council has already argued, the court may also direct for accounts of profit, which is any sort of profits which have been gained by the defendants by using the works of the proprietor without their consent. If it may please Your Lordships, the Council would now like to conclude with the rebuttals. It has been an honor arguing before the Honorable Court.
I would be firstly only addressing the concern raised by the Learned Sister Council with regards to their rebuttal. Firstly, they had made a claim that the matter brought is of national concern. Even if it was brought for a national concern, there is a similar suit filed before the Delhi High Court in Annie vs. OpenAI, analyzing the working of an AI in a much more detailed manner than the petitioners have filed before this Honorable Court. So this is merely a publicity interest litigation in the present case scenario. Secondly, they had also related Article 21 and they claimed that the privacy is being violated through the moral rights. I will admit that moral rights includes the concept of privacy, not in India, in the case of United States of America. With this same thing, I would like to submit an attachment to your bench. Your Lordships, this was the decision given by the US Copyright Office in registering a trademark. If you refer to the previous page, there are two images. One is an image taken by a person, Mr. Sani, and the next one is an image the next one is a famous painting of Vincent van Gogh. What Mr. Sani did, he used an AI system which took Van Gogh's style and used it in his artwork. And this painting was called a Suryast. He applied for a copyright in India and in the United States of America. As it already mentioned, US follows the highest degree of protection for originality with the modicum of creativity doctrine. The court, the highlighted part is the reasons why the US Copyright Office rejected the copyright for the same. However, the present status of the same painting, AI generated painting in India is that it is registered. So as per Indian law, AI generated outputs, the mere copying of an artist's style and combining it with a picture is protected as per the Indian copyright law. That being the case, this being an artificial intelligence system that analyzes the artist's work and recreates and regenerates a new work is very well entitled to the protection of originality even by American standards. Additionally, Your Ladyship, they also relied upon a substantial similarity test and they again recited that 65 to 80% was being used and that counts to substantial similarity. I would like to make one simple contention. If I have a painting which is all blue and in the center of a painting there is a man on a white color ship, a very tiny symbol, and another painting which is all blue and in the center there is a man on either surfing or on a sailboat, which is slightly different. However, the substantial part of both the paintings is what is in the center. 99% of the painting might be similar, but that 1% is where it is different. And by that 1%, both should be entitled to copyright protection. Therefore, the claim made by them that 65 to 80% is similar is not at all valid until they come before this court and show with both the paintings where the substantial part has been copied. Additionally, Your Lordship, there was also a claim that under 52(1) clause B, it is only for incidental storage. And their claim is that the data is being stored primarily for the training purposes. Firstly, they have no proof to show that the working of this specific artificial intelligence system is storing the data itself. Additionally, assuming it is storing, under 52 clause 1 clause A, it, what was the request? Under 52 clause 1, certainly, Your Lordship. Under 50.
Can I ask?
Certainly, Your Lordship. Under 52 clause 1 clause A, it does allow for personal research. If as a human, I would like to recite the same point I had made during my submissions. If as a human I am allowed to read this artwork, review it, make analysis of all the different elements used in it, and recreate an artwork, why as a human I am not allowed to create a tool capable of doing the same? If I would like to give a very more simpler example. If I carve something out of rubber, stamp it on ink and stamp it on a piece of paper, I have created an artwork on the piece of paper. That should be copyright protected. I can recreate it how many ever times I want. But the fact that I have created it should be entitled to copyright protection, and if somebody else modifies the rubber and creates something else out of it, and there is a new piece of artwork being created, that would be a different work, Your Lordship.
A question regarding the jurisdiction.
Certainly, Your Lordship.
If I want to get them restrained, if I want to get some compensation, I can approach a civil court.
Certainly, Your
At the
Lordship.
same time, if I want to get a declaration regarding the constitutionality,
Certainly.
regarding the status of my fundamental right, that has to be a precedent, a history or the country for the coming years. So I have to approach the Supreme Court, right?
Most definitely, Your Lordship. However, Your Lordship,
How do you address that?
Your Lordship, their claim for violation of a fundamental right in the present case goes in 3 steps. Firstly, artists make a work. AI copies the work. AI misrepresents it to be the artist's work, violating their moral rights. If it's violating their moral rights, it's related to the right to privacy. That is a fundamental right being violated, and they are approaching before this honorable court. My contention is that in the second step, where the AI copies the work itself, they are wrong because the AI is generating a new image. It is not a copy of the artist's work. If a human is allowed to be inspired by artwork and create an image and receive copyright protection for the same, a human-made tool, which is AI, as similar to the rubber stamp in the present case, should also be entitled to get copyright protection indirectly through the same, Your Lordship. In addition to the same, addressing a question that was posed to my learned co-counsel in relation to the ownership aspect of it, an artificial juristic person can very well be the owner of a copyright if it is done during the course of an employment by an employee under them. An employee under Tech Innovate Private Limited created this artificial intelligence system. The artificial intelligence system acts as the rubber stamp capable of producing different images. So therefore, Tech Innovate Private Limited would very well be entitled to the copyright ownership of the same, Your Lordship. If there are no further questions and I may not be of any other assistance, the council would like to leave the podium. Much obliged, Your Lordship. It was an honor arguing before this court.
I have a short recess. ആലോചിച്ച്
ആലോചിച്ചാൽ മതി.
May stay here.
Warmest good afternoon to one and all present, esteemed dignitaries on and off the dais, honored judges, respected faculty members, Moot Court members, beloved participants who are all winners in our eyes. Welcome to the second Mount Zion National Moot Court Ceremony's Valedictory Ceremony. A round of applause to all these winners who are all winners in our eyes. Myself, Shika Sophia Bobin from S1 BBA LLB will be your host for the day. We have finally arrived to our immensely anticipated moment, which marks the successful conclusion of days of intense learning and growth. Before we continue, let's bow our heads and hearts in reverence as we seek blessings, wisdom, and protection from the divine. May our prayers be filled with hope, love, and gratitude. I request you all to kindly rise for the prayer. Here I invite the college choir for the prayer.
So I turn towards you to follow you, my God. So I turn towards you to follow you, my God. So I turn towards you to follow you, my God.
With a vision that transcends boundaries and a passion that ignites excellence, Advocate Hiradas has been the driving force behind our Moot Court Society's achievement. I invite you, ma'am, for the welcome speech.
Thank you, Shika. Esteemed dignitaries, respected faculty members, our honored guests, and my dear students. It is such an honor, proud, and happiness moment to me to stand right here. Over the past 2 days, we have witnessed the legal intellect, the argumentation, the advocacy skill, and the competitive spirit of all the participants along with all the members of the Moot Court Society. And in this occasion, I feel so proud to extend a warm welcome to each and everyone who are present right here with this valedictory function of the second Mount Zion National Moot Court Competition. First and foremost, I extend my heartfelt gratitude to our respected principal, Dr. Gifty Oman, whose constant encouragement and leadership have been the foundation of our success. Ma'am, we are truly grateful for your presence, and I welcome you to this valedictory function. I also take this opportunity to welcome our esteemed chairman, Dr. Abraham Kadammanitta, whose visionary leadership continues to elevate Mount Zion Law College. Sir, your contributions to legal education are truly inspiring. Welcome to the valedictory function, sir. Even in his absence, I would like to give a special welcome to our Managing Director, Mr. Joseph Abraham Kadammanitta, whose unwavering support strengthens the academic excellence of our institution. And it's my privilege to welcome our Vice Chairman, Mr. Samuel Abraham Kadammanitta, whose dedication towards the institution and fostering legal education has played a crucial role in this institution's growth. Sir, you're welcome to this ceremony. And now, a special welcome to Reverend Father K. Varghese, who is our manager come guiding light. Even in his absence, I welcome him to this function. I would also like to extend my heartfelt welcome to the judges of this final, that is retired Justice Muhammad Ibrahim, Advocate Divya Unikrishnan, and Advocate Vinod George for their presence in our finale. Even in their absence, I welcome them to this function. Now I would like to invite the most important person, our director. She is not right here, but I welcome our dearest Rashmi Miss, even in her absence, to this function. Actually, we really miss her presence right now. If she was here, she would be the most happiest person for us and what happened today. And now a warm welcome to Assistant Professor Krishna Priya L and Assistant Professor Ananda Lakshmi, who is also the Executive Coordinator of the Moot Court Society, for their inspiring foundation, support, and even sometimes the criticisms that we have got for becoming the better persons that we are today. Welcome to the function, both of you. I would like to invite our participants who are the most beloved guests of our current celebration and valedictory function. Now I invite the most important person, as I said in the morning, the person who is like in the air of Mount Zion Law College, the person who we think that our hope of resort, to whom we can go whenever we need something for the Moot Court Society, that is none other than Joseph, Mr. Kiki Jose, I invite Joseph to this function on behalf of the Moot Court Society, each and every member who is here. And now I would like to welcome Dhyan Prakash, Ijaz Ahmad Siyad and Abhay R. Gunithan, the founding member, president and secretary of Moot Court Society, to make this dream come true. Welcome to the function, and I thank you so much for standing with me from the starting itself and right now. We are actually sharing all the criticisms, all the nice words, and we scold ourselves, each other sometimes. They scold me and I scold them. This is what happens. And now I would like to invite all the participants, all the winners, and there are no losers actually. Some may get a trophy, but some may get life experiences. In both the perspectives, you are the winners. I would like to welcome each and every participant who are here with us for the celebration and valedictory function. We welcome you to this ceremony. Now, last but not the least, my dear Moot Court Society members, volunteers, you are everything. You are the Moot Court Society personified. You are my 1 a.m. calls if I need something. They are here. See, it will be like, I need a photo for the Moot Court Society, I need a brochure. There will always someone who is ready to do this. Can you do it? They won't say, no, I can't do it. They'll make, okay, we will make it happen. Somehow they will make it happen. They never said no to me, but they always calls me and I do the same to them. But at the end of the day, they will do what the Moot Court Society needs. I welcome each and every person who stood with me for making this dream come true. And now I invite my colleagues. Without your support, your care, your determination to stand with us, it won't happen right here. I welcome each and every colleague to this function. Before ending this duty I have assigned with, I would like to say one thing. See, this is not a moment not just to celebrate the victory. Sometimes we should take a moment to reflect our struggles also. If you know that everyone in our life, there will be always one person who will say that you can't do it. See, there will be one person in our life like, you can't do it. Drop the idea right here. You're not capable to do it. Like this, our Moot Court Society also had these struggles. And from the bottom of my heart, I would like to say to those people who said you could not, you would not, and you must not, thank you. Your disbelief, your doubt, your discouragement made us better, push harder, stronger, and the fighter we are today. Thank you so much for unknowingly making us better, stronger, and what we are right now. I welcome each and every person who stood with us, who didn't stood with us, who criticized us, who was there for our support, our foundation, to the dream of the Moot Court Society of Mount Sion Law College, the finale or the valedictory function. Thank you. Have a memorable moment.
Thank you so much, ma'am. As the leader of our institution, our respected principal, Dr. Gifty Uman, has been instrumental in shaping our academic excellence, fostering innovation and nurturing young minds. I welcome you, ma'am, for the presidential address.
Welcome one and all. It is indeed a day of celebration. Mount Zion has been looking forward to this day when we could have an offline national moot court competition. And as the principal, I'm really thrilled that we have successfully taken it up to the pedestal. Today we are at the point where we are bidding you farewell with lovely gifts. And we believe that when you go back to your home places and to your home institution, you will carry with you all, this aroma and ambience and love and care that we have bestowed upon you through our Moot Court Society. I'm very sure you will have very beautiful memories to carry on. Am I sure? Yes? That's it. So that's the spirit of Moot Court. Winning and losing is not at all the spirit of it. It is a spirit of interacting, knowing the institutions over and above your own parent institution, going through the trials and tribulations and tough times and coming out and shining and being a refined gold. As refined gold you come through. And during that process, you make so many friends across the nation. That is the privilege of a Moot Court. And that is what you are all here for. I think the last few days, you've been taken care by the Moot Court Society from the moment you landed into Kadammanitta, right? And it was a beautiful journey that you had throughout. That is it. So if you are with us, that's the happy moment that we have. This is a moment I congratulate all the participants who came across from different states of India, and each and every person who is here with us, the Moot Court Society and the teachers and every part and parcel which has contributed to the well-being and doing well of this Moot Court Society. This has been a dream. I'm just a principal who came in late, I said. This is a dream which has been, taken care and wanting to bear fruit through years. So many teachers are involved in it. Like I said, Rashmi Miss, Hira Miss, Krishna Priya Miss, Ananda Lakshmi, all these Ijaz, and all those. It's a dream they've been carrying. I just saw it happening in front of me. So let's give them all a big applause. Can you all give them a big applause? I'm very happy all of you are here. I take time to welcome our chairman, Dr. Abraham Kadammanitta sir, who has seen this happening in front of us. I welcome Sam sir, the vice chairman. I welcome Joe sir and each one of you to this valedictory function. Thank you.
Thank you so much, ma'am. As we navigate the landscape of innovation and excellence, one person has been at the helm, steering our organization towards greater and greater heights, our Honorable Chairman, Dr. Abraham Kadammanitta sir. I am excited to hear his vision for our future endeavors. I invite you, sir, to enlighten the crowd.
First of all, our principal, who has taken much initiation for this program. The first time I saw that Moot Court competition, and I talked to the chief guest. I just came just before a few minutes, and they told me the ambience, it is almost like a very Supreme Court ambience. Beautiful Moot Court. All the ambience, everything, they like it very much. They are all retired judges, retired advocates, and public prosecutor and all that aspects they worked. So they know it, what is the Moot Court and what is the validity. So I appreciate that. And the students, those who come from Bangalore and Madras, that's what I can appreciate them. Those who participate outside. You always remember us, even though you are in Bangalore or in Chennai or in Delhi, anywhere. Remember us outside. So that is a great opportunity God has given you to come all the way from that place to here and attend this competition. And I don't know who is winning. Who is the winner? Will you announce the winners? No, not yet. See, surprise coming up. So anyhow, let us take us a very good, sweet, spiritual and a competitive way, accepted that, whatever it meant. Anyhow, God has given you a good atmosphere. I told many times to the attorneys or advocates or the students, those who come, even the students, those who came yesterday to my home, and I told you should go to each and every, even from Muslim court, and sub-court and district court and the high court and the Supreme Court. You should go there. When you get a vacation, you should go and spend the time there. Watch how the Chief Justice come to the chair. It's very beautiful to know that. And all the ambience, how that client, the plaintiff and defendant, both comes in both sides. Advocates, how they perform their case. So all these things you should see. The experience, very, very great thing. You, this is not within a one day or within a year, you will get it. It takes time to get it. You should practice with the senior good lawyers. Someone asks you which college you study, same day they ask you, who was your senior? Whom you practice with that. It's a very valuable thing. I remember that Hari Salve, you have to see the man, how he comes to the Supreme Court. Like a big crowd, minimum 25 to 30 advocates around him, and he is going with all black coat and their performance. Judges itself, what's the when he comes to the court, judges also alert. That's a great thing. Even in the High Court, we have lots of good senior advocates out there. Always seniors are seniors. If you work with some seniors, then you get the lesson. Nothing, you won't get everything from the college. That is the common sense come from, not from the book of law, that come from God. So that's the most of the judges, most of them, they pray before they take the decision of the cases, before they announce the judgments. Anyhow, I'm thankful to Mount Zion students and especially our principal and all the staff. Not one, I can say all the staff. They are all participated in this program, perform a wonderful performance. It will be our proud, Mount Zion proud, and those who participated, let them all, God may abundantly bless you. One doctor can be only a surgeon or he is a doctor. Teacher, he can only a teacher or a senior teacher. But advocates, no. Advocates can be judges. Judges go on from municipal court to Supreme Court. There is no barriers, there is no line between that. So your performance, God's grace, God's blessing, it will take you to the Chief Justice chair. That is there, that is there. You should know, I can be the Chief Justice of Supreme Court one day. You should see that vision. Where there is no vision, there the people perish. So you should have that vision. Yes, I want to be like that. Always keep that. Always keep the truth, piety, and the discipline. You are the people who keep the law. So make sure I maintain the law. Also the advocates, they are the lawmakers. So you should see, I should keep the law. We should not take the law in your hand. Obey the law. Keep the discipline. That is a great thing for our community area. Mount Zion principal and all the staff and management, they are trying to build up a beautiful career and also a good performance. Anyhow, once again I thank the participants from Bangalore and Chennai come to Mount Zion. Also our students, those who participated, they also took much more pain and all the good performance. I appreciate all of them. And let God bless you abundantly. And we'll meet again. And thank you for this opportunity you have given to me. Thank you.
Thank you so much, sir. Your words were truly inspiring. I can hear a lot of heartbeats echoing right now onto the dais. Since the past 2 days, I've been your host, and every time I got on stage, I could see your eyes lit up like fire in the night sky. I could hear the echoes, and I could see the faces of yours lighted up in anticipation and excitement. And every time I said, okay, the results will be announced online, I could see the frowny faces. Oh, we have to wait another few hours for the results. So we have finally reached the most anticipated event, the valedictory ceremony of the second National Mount Zion Moot Court competition. So let's start it with a big round of applause for all the participants who have come over from all over Kerala to take part in the event. Yes, as ma'am has said, there are winners, but then none of you are losers. All of you are winners in our eyes. So now it's time to congratulate our winners and participants who have demonstrated exceptional talent, expertise and commitment. We acknowledge their hard work, perseverance and passion that have led to their remarkable accomplishments. So to give the certificates to the participants, I invite Advocate Hira Das onto the dais. Team 001. Amal Ashok, Malavika Arun and Fatima KM. Give them a round of applause, everyone. A round of applause to Team 002. Next, I invite Team 004, Gopika G. Nair, Nivedita K. and Devaki P.S. Let's invite them with a round of applause, everyone. Next, we call upon the finalists, Team 005, Niharika Batra, Aniza KB, and Asha Narayanan. Team 006, Vismaya CP, Akshara BR, and Abhirami Raju. Team 008, Devananda A, Shweta S, and Gauri SS. A round of applause for the participants, everyone. Team 009, our next finalists, Sahitya Nirupan, Shruti, and Sneha. Anisha Devi Jayanadar. We move on to the special awards. I invite Hira ma'am to give the award for the best memorial. The best memorial goes to Team 004. I invite Anandalakshmi ma'am to give. I invite Anandalakshmi ma'am to give the award for the best memorial of the second National Mount Zion Moot Court competition. Team 004. Kusat. Team 004, Kusat. Next, I invite our respected administrator, Mr. K.K. Jose, to give the award for the best researcher. Again, Team 004, Naval EPS from Kusat. Next, I invite our principal ma'am, Dr. Gift Human, to give the award for the best advocate. So, one of the most special awards, the best advocate of the second Mount Zion National Moot Court competition goes to 009 Sahitya Nirupen from School of Excellence, Chennai. Give him a round of applause, everyone. Next, I invite our respected and most beloved chairman, Dr. Abraham Sir, to give the award. To give the award for the winners of the second Mount Zion National Moot Court competition. Yeah, the trophy is quite big. So we have two finalists here, 009 and 005. Can I hear a round of applause for the people who think it's 005? What about the people who think it's 009? Shall I announce the names of the winners? We've been waiting for quite a few days for this. I need more enthusiasm from the crowd. These are the winners of the second National Mount Zion Moot Court competition 2025. And the winners are 009 Sahitya Nirupen, Shruti and Sneha. Let's give them the biggest round of applause, everyone. to give the awards to the runners-up. These are our runners-up for the second National Mountain Competition 005. Niharika Batra, Aziza Kiwi, and Abhrami Raju. Let's give them the biggest round of applause, everyone. They're all winners in our hearts. Congratulations, School of Alliance, Bangalore, for being the runners-up for the second Mount Zion National Moot Court competition. And the biggest congratulations goes to our winners once again, School of Excellence, Chennai. Woo! Under the guidance of our Honorable Vice Chairman, Mr. Samuel Abraham Kadammanitta, we have achieved remarkable success and growth. I invite you, sir, to the dais to share your insights and experience. Let's welcome him with a round of applause, everyone.
Most respected Chairman, Dr. Abraham Kadammanitta, our Principal, Mr. Madam, our Director, K.K. Jose, and all the faculty, especially the Moot Court Society students, faculty, everybody, and all the students that came across from India to our college. We really congratulate you because, like the person said, there is no losers, everybody is a winner. When you decided that you want to come and be a participant, there you are a winner. There's a lot of people out there, didn't even take a time to come. A lot of people were invited, but few came. Thank you for coming to our college. This is just a start. This is our second national moot court we are conducting. But next, we are going for an international moot court. Hopefully, by grace of God, next year this time. I want all of you to come and be a part of that program. And I congratulate the Chennai team, the Bangalore team, the Kerala, everybody from Kerala. I thank you for coming, spending these 2 beautiful days in this campus. May God bless you. May God bless Mount Zion. And I want to especially thank all the faculty and the students, like all the people that are involved in this society. In all your hard work, you worked in the daytime and the nighttime, and everything you did. I thank you for your time spent in this program. May God bless you. Thank you very much.
Now I welcome our administrator, Mr. K.K. Jose, sir. His leadership and guidance has been monumental in shaping the vision and strategy of our organization. I invite you, sir, for the felicitation.
Respected Chairman, Vice Chairman, Principal, Hiraman, all the faculty members, participants and my dear students.
So, it was an excess speech. In excess speech, what do you call in Malayalam? Adhika Prasana. So if we make again a speech today, what will it become? Now yesterday I wished all of you to become what? Do anybody remember? Burse, yes. Today I would like to 2-3 minutes I will take. Okay? Can anybody say in the history who was the wisest king and judge who ever lived in this world? Solomon, you are correct. Solomon was the wisest king and judge who ever lived in this world. He never studied in Bangalore or Chennai. But can you say where he studied? He studied in Zion. Zion. That is true. I am coming to that point. Can anybody say the father of Solomon? Can anybody say what is the name of the father of Solomon? King David. King David, yes. When King David died, Solomon was a young boy, and he was to take the responsibility of ruling the entire nation. But he came to the Lord and said, I am a poor boy. How can I manage the entire population? Then he made an offering and sacrifice to God. And God was very much pleased with Solomon's sacrifice. And God asked Solomon, you ask me anything, I will give you. Whatever you ask, at this moment I will give you. Can anybody guess or say what was the thing that Solomon had asked God? Can anybody say? Solomon replied to God, my father, I want wisdom and intelligence to rule the entire nation, the entire people that you have given to me. Our Lord, the Almighty, is the greatest of all judges and lawyers. He was very much pleased. And he answered Solomon, Solomon, I am going to give you what you asked, intelligence and wisdom. But because you have not asked for a mighty kingdom, because you have not asked for a mighty army, because you have not asked for beautiful wives, because you have not asked for intelligent children, because you didn't ask for a vast nation, because you didn't ask anything worldly, I am going to give you all these worldly prosperous things. I am more happy because you didn't ask that. If you had asked that, I would not have given you all these things. I am going to bless you by giving everything in this world which you didn't ask for. The greatest of all judges and lawyers, the Almighty God. So King Solomon had a very wise judgment that you can read in the Bible. I don't have time to explain it now. But my dear future lawyers and judges, one thing I ask you today, when you finish this course, or this postgraduate course, whatsoever it be, or tonight itself, why do you postpone?
Respected dignitaries, esteemed speakers, my faculties, all the participants, and all my dear students. It is really an honor to stand here before you on this auspicious occasion as we mark the end of our second National Moot Court competition. But it is our first national offline Moot Court competition held by our Mount Zion Law College Moot Court Society. And I feel really proud to be a part of it today. And this opportunity, I take this opportunity to congratulate each and every participant who have participated and who came from different colleges to attend our National Moot Court competition. And I would like to congratulate each and every participant, and I would literally say that you all are winners. The fact is that only one team may get the trophy, but you all have worked really hard, and it means that your hard work needs to be recognized one day. So keep on trying till you get recognized. So all the best. Congratulations to the future lawyers.
The gavel that strikes not just to maintain order, but to ignite passion. And a heart that beats not just for justice, but for the pursuit of excellence. Mr. Ijaz Abraham Ahmed Ziad, the president of Moot Court Society, has been the driving force behind our Moot Court success. I invite you to share your thoughts. Our dearest president, let's welcome him with a round of applause, everyone.
So just got nearly converted, sorry. Respected dignitaries on dais and off the dais, faculties, teaching staff, non-teaching staff, and all the participants, my juniors, good evening to you all. Not taking a lot of time here, but I just want to thank my management, my principal, and my entire Moot Court Society and the volunteers, and especially the participants for trusting us, for coming and taking our hospitality. You guys have any complaints? No? Yes? Okay. Still in the shock of the conversion, sorry. But I just want to say that, we were planning this for last, we started planning it 2 years ago. We conducted an online Moot Court competition, but we actually started it 6 years ago when I went to the Mount Zion Medical College to meet Samsa for discussing the budget, and it was a great discussion, guys. I will never forget that day. And me and Dan went, so he will also never forget that day. From there till this day, we had faced so many hindrances, but my management didn't, leave my hand, so I'm still here. And my principal was always behind me, and I am very thankful to my chief executive coordinator, who is Hira Miss, who in a way, who created me as a motor, as this everything. She was the mentor who I had, and God-given mentor, I can say right now. But what I'm trying to say is, even as we had all these hindrances, my entire Moot Court Society declared in one voice that we will not go into the night silently. We will not vanish without a fight. We will exist. We will, continue to be here. And because of that, today we can celebrate success of the second Mount Zion National Moot Competition 2025. Thank you.
I'm really sorry for the near conversion in Jaseta. So please join me in welcoming one of the maestros of our success story, Mr. Abhay R., Secretary of Moot Court Society, with a warm applause to share his valuable insights.
Greetings to one and all presented here, respected dignitaries on and off the stage. First of all, congratulations to both the winners. You guys really did well. Apart from them, I want to congratulate the rest of the 6 teams. Without you guys, we can't do this. You got initiated and were good, a very good effort regarding the initiation of the team. Okay. Today morning, I want to prepare a speech regarding this. My chief coordinator first said that this college, I don't mean create a controversy regarding this. This is the request for the management, okay? Wait, I can explain. As the chief coordinator already mentioned, in this college we have 2 sets of authority. One for criticizing, and that same authority will appreciate us. And that criticism is also a guidance, and they will put forward the essential ingredients and the pathway to the Wait. The second set of authorities, first they do criticizing, second criticizing, third criticizing, and this criticizing go on. That I was discussing, that was today morning. I want to prepare a speech noting this, guys, that this is what we did for the replay you needed. This is the Moot Court Society's effort for the last 3 months, and it's been emotional and a proud moment for me. And since the dinner is already ready, I don't want to thank it. Okay, thank you.
Thank you, Abhay Chetta. As we gather in this hallowed hall of justice, where minds are sharpened, arguments are crafted, and futures are shaped, it is my distinct pleasure to invite a leader who embodies the spirit of justice, Mr. Dhyan Prakash, the founder of Moot Court Society. I invite you to share your valuable words with us today.
I was unfortunately slated to be the last speaker here, so I am very crunched for time. So I'm going to be very quick with the thanks. I have to thank the management, the entirety of it, for making this possible and allowing me to be part of this. I have to thank my team, honestly, the entirety of Mount Zion Law College Moot Court Society, especially Hira ma'am, Ijaz, and the Lakshmi Miss, and Lakshmi Miss is not here. And there's a lot of people I'm missing out in this story. But the vision, I won't say just me, I had it, a lot of people had it, but I strive to make a Moot Court Society in this college for a long time. And I tried to make it happen, I think on and off for about, from the second year I was in this college, since 2021. And the only reason, I have to say, I will make this a very personal note, the only reason I was able to achieve this is because one day I had this man called Ijaz Ahmad Siyar, this man behind me. And somehow, whatever I did just clicked. And I will especially thank him and Gifty man, Sam sir, and Abraham Dalman sir, and all the members of the Moot Court Society again. I'm thanks for time. I want to say a lot of things personally for not only allowing me to be a part of this even after I passed out, but also to make a dream of mine come true. I was in when the budget for this was passed, but I could not be part of this as official member because I passed out, unfortunately. Seeing this entire development of the Moot Court Society, now I wish if I had stayed back. But anyway, I'm so grateful for everybody who participated, especially the Chennai team. I was there the first time around when they won this, and I'm so happy that you guys came back. And for every other team who came here and who put in the effort, a big thank you from all of us. So I'm going to conclude my words. I won't stretch it out anymore.
One of the most important skills for an advocate, I would say, is observation skills. So if you've seen me running around here and there, there's one name I call the most. Any guesses? One name I've heard. You heard a lot from my name. Praise! Idara! Praise! Kayat! Yeah, so now it's time to invite one of the guardians of this legal temple of learning, one of the champions of critical thinking, the Joint Secretary of Moot Court Society, Praise Givarki is ready to deliver the vote of thanks.
Much obliged. A moodfully remarkable evening to one and all present out here. Finally, as we put down the curtains, let me take a moment to express my heartfelt gratitude to each and everyone who worked behind this to make the second Mount Zion National Moot Court competition a grand success. Firstly, I would like to thank the Almighty. Secondly, I would like to thank our chairman, Dr. Abraham Kadammanitta, Vice Chairman, Mr. Samuel Abraham Kadammanitta, Managing Director, Joseph Abraham Kadammanitta, Administrator K.K. Jones, Manager, Reverend Father K.A. Verghese, and our most beloved Principal, Dr. Gifty Umam, for their support, for their continuous support. We also extend our sincere gratitude to the esteemed judges. And next, I would like to thank Dhyan Prakash, who is a founding member of the Mount Zion Law College Moot Court Society, for his continuous support. I would also like to thank Rashmi Miss, although she is not here with us. But thank you so much, Miss, for your unwavering guidance. Next, I would like to thank all the participants who have gathered here from different parts of India. Thank you so much, guys, for coming. Thank you for all your support and all the cooperation.
cooperation. Next, taking a moment, I would like to thank that one person who literally built this Moot Court society from the scratch. You know what? She has gathered every single stone to build this empire. But you know what? She can throw that stone at us. None other than Advocate Sheila Das. Can we give a huge round of applause for her? Thank you so much, miss. She will literally scold us like anything. But at the end of the day, it's like only I can scold you. No one else can point a finger on you guys. Thank you so much, miss. And with that, I would like to thank Advocate Anandalakshmi miss, Advocate Krishna Priya miss, for your constant support to the society, and also all the teaching and non-teaching staffs of Mount Zion Law College. Thank you so much. Next, I would like to thank the three pillars of Mount Zion Law College Moot Court Society: the president, the secretary, and the treasurer. It was really a great pleasure for us that we could work under your leadership. In this whole journey, you proved that you were a true leader. Thank you so much, three of you. Next, quickly, I would like to give a shout out to all the committees, the legal titans, our court officers, led by Vaishnavi. Next up, our team manager, led by Megha. Lexicon, our culturals, led by Sneha. Next is our discipline committee, led by Ijaz. Medical committee, again led by Sneha. Transportation and accommodation, led by Rishikesh. And thank you so much for the good food, Albi and team. And finally, the last but not the least, the Legal Lens, the media group. Thanks to all the Moot Court Society members, the volunteers. Thank you so much, everyone, for making this event a huge success. And special thanks to Shika for elegantly hosting this ceremony. Literally, this 2:30 today, I said her that you need to do the anchoring, and she made a wonderful script. Can we give a huge round of applause for her? Thank you so much, Shika. And as we bid goodbye to this Moot competition, we carry a lot of memories, lessons, and friendships that will last a lifetime. Thank you so much. Thank you so much once again. Until we meet again, MZLC MCS signing off.
Thank you so much, Grace. Now I request you all to kindly rise for the national anthem.
Zana